Today's hearing will examine lawsuit abuse of the Telephone Consumer Protection Act, or TCPA, as we will likely refer it. The TCPA is enacted in 1991. It established several enforcement mechanisms, including a private right of action for consumers to bring claims for receiving certain auto-dialed calls, pre-recorded calls, and faxes they did not consent to receive. This law also established a private right of action for certain telemarketing calls made in violation of a consumer's status on the federal Do Not Call list. At the time of its passage, the TCPA was a sensible legislative response to consumers and businesses who were overwhelmed with unwanted calls and faxes. But with advances in technology, government regulators have struggled to interpret the TCPA's antiquated language to new situations. An increasing amount of regulations and court interpretations has produced a lack of clarity that is empowering plaintiffs' attorneys to sue companies that are contacting their customers for legitimate reasons. Damages can easily become exponential, given that each violation can amount to $500, even if no actual harm to the consumer was caused. Plaintiffs' attorneys are encouraged to use abusive litigation tactics, such as waiting for these violations to pile up. A lawsuit against Rubio's Restaurant provides an unfortunate example of these tactics. Rubio's is a California-based restaurant chain that uses a messaging system to send food safety alerts to its employees. When an employee's cell phone number was reassigned to a person who was not an employee, the messaging system continued sending alerts to that number. The restaurant didn't know that the number had been reassigned because the telephone company is not required to notify the business. Over time, the person with this phone number waited to accumulate 876 alerts before filing a $500,000 TCPA lawsuit. This is clearly an abuse. Rubio's Restaurant isn't the only business that's been unfairly targeted with TCPA litigation. According to the U.S. Chamber of Commerce's Institute for Legal Reform, American businesses are besieged with lawsuits brought under the TCPA, with many attorneys and individual consumers making their living through suing companies for any text, any call, or any facsimile placed to numbers that had been provided to those companies for such communication purposes. Indeed, it is not rare for alleged statutory damages for punitive class actions brought under the TCPA to be billions of dollars when large companies with millions of customers are sued. Small businesses, too, are finding that their very existence threatened by the TCPA lawsuits. A Federal Communications Commission, which is tasked with interpreting and enforcing the TCPA, has noted an increasing number of TCPA-related lawsuits in recent years and believes this is due to a lack of clarity in the law's interpretation. In 2014, Commissioner Michael O'Reilly stated, "Over time, as the FCC and the courts have interpreted the TCPA, business models and ways of communicating with consumers have also changed. As a result, the rules have become complex and unclear. In addition to prohibiting abusive robocalls and junk faxes, which was the original intent, the rules are creating situations where consumers might not receive notifications and offers that they want and expect, and where new and innovative services and applications that help friends and family members communicate with each other could be restricted." My hope is that today's hearing will explore the unintended consequences of the TCPA and the lawsuit abuse, which has grown into an industry and arisen from it. And although this law may require an update, we must keep in mind the original goal of the TCPA, which is to protect the privacy interests of this nation's consumers. I want to thank our witnesses for being here today. I look forward to your testimony. The chair now recognizes the ranking